Aloha kakaya or aloha kako. My name is Kealapono. I am so very humbled to be here to help facilitate and host this amazing experience with Dr. Lance Collins, who's going to be sharing his mana'o today about cultural rights, civil rights, and of course the private property aspects here in the Aina in our Pai Aina across Hawaii. For those of you guys that are joining us, we will ask you guys to to mute your mic so that we'll have a little bit less of the background noise. If we do forget Kalamai, it's not a big deal. I'll go ahead and help and go and turn it off. But please do not take offense if you guys get your mics muted for a minute. So in just a few minutes, we'll go ahead and start. And I think actually we can go ahead and start. So without further ado, let's give a warm aloha applause for my favorite, Dr. Lance Collins, who I had the opportunity to share so much to share some calls, and it's such a pleasure to finally be here and to have this day. So again, without further ado, Dr. Lance Collins here talking to us today about cultural rights, civil rights, and of course some of the private property aspects here across our Pai Aina. Dr. Collins, it's over to you.
Aloha and mahalo for the introduction. And mahalo to everybody who is attending today. And I guess this is being recorded, so if you weren't able to attend today, when you're able to later. I just want to give a little bit of an introduction, a little bit about who I am and why I'm going to be talking about these things. So I practice as an attorney, a private attorney. I'm based on the island of Maui and Makauao and Alelele, and I do things both in the circuit courts and in the state appellate courts. And although I try to avoid it, I am involved in 2 cases presently in the federal courts, but I typically just practice in the state courts. I also have a Ph.D. in political science from the University of Hawaii, and the types of research that I do has to do with the comparative legal history of both Hawaii and the Philippines. Primarily with the Philippines, it's primarily during the American colonial period, of course. For Hawaii, the American colonial period hasn't ended yet, so it goes up to present there. So, okay, so when I was asked to speak at this conference, I was given a relatively broad range of things that I could possibly talk about, and I decided that I thought what might be most helpful based on what they had told me was to talk about private property, cultural rights, and civil rights. And this isn't really I'm not going to be talking about it we will be talking about the law, but it's not primarily from a legal perspective. It's more from a broader perspective to help put context for the legal discussion. So I wanted to start with a quote from a historian named Peter Judson. And what he said was, quote, "Imperial institutions, law, and administrative practices played crucial roles in giving shape to the more successful forms of nationalism. Distinctive nationalist movements developed in response to and operated very much within the idiosyncratic institutional, legal, and constitutional structures of the empire." So I want to start with that because I think it's very important to be mindful of using legal tools in the American legal system is very much gives shape to the responses that individuals and communities have in terms of resisting or opposing empire. And I think it's important because as we discuss all of these things, there's a history and a context, and choices constantly have to be made about how to engage the others or the other side or whatever in that. And so I just wanted to start with Judson's quote because of that. So, okay, with that said, what is private property? So private property is not a real thing. It doesn't have its own existence. It's not like a rock. It's not like a tree. Private property is a way, it's basically an idea. And that idea, means that the state gives or grants power of control over something to someone to the exclusion of others. So private property is an idea or a metaphor or a concept where the state grants the power of control over something to someone to the exclusion of others. So the most important thing in that is that there's a state. And what is a state? Well, the state is the also doesn't have its own existence. A state is basically a way that the power in society is organized that basically has total control over the legitimate use of violence. And so a couple of other things have to do with the state as well, but that's what the state is. So the private property cannot exist without a state, because then it's not private property, because it's not the state granting the power of control over something. Yeah, and so I think fundamentally it's the state's use of legitimate violence that enforces its designation or recognition of who gets to control something by the rest of society. So that's basically what private property is. So it's not a real thing. It's basically an idea or a designation, a relationship. And anyways, liberal economists, they say that private property is a relationship between an individual and a thing. So with respect to land, they would say that basically the concept of real property is a relationship that an individual has to land. But that's one way of looking at it. There are others. So before I go on to the others, there's a New York justice, relatively famous American jurist named Benjamin Cardozo. And what he said that private property was, and the only reason why I'm quoting him is because I'm going to talk about this a little bit later when we get into gathering rights, is that he said, quote, "The bundle of power and privileges to which we give the name of ownership is not constant through the ages. The faggots must be put together and rebound from time to time," end quote. And so this quote from the 1920s basically is what he's saying is that private property is like a bundle of sticks, and each of those sticks is a power or a privilege that goes with it. But what he's also saying is that what that bundle of rights are, or bundle of sticks are, changes throughout time. And so there isn't some, from time immemorial, way of understanding private property that has existed. Okay, so I hope I'm not boring people to death. So how liberal economists or property theorists see private property as a relationship between an individual and a thing is one way of looking at it. Another way of looking at it, and I would say that this probably started with Karl Marx, is that private property is a social relationship, that it is a relationship between individuals, namely the one who has the power to control and the one who does not. So, for example, the owner of property uses their ownership as a way to extract value from the one who does not own the property, but uses the property to labor. So I think most people, that's easy to understand, right? The owner of a business owns the tools, possibly the land, and the worker who works for the owner basically gives their labor, but they don't get all of the value that comes from their labor because some of it goes to the owner because the owner's the owner. So another way of looking at private property is that really it's a relationship between individuals. The thing is sort of a secondary thing for private to understand private property, that private property is really a relationship between individuals. So that's another way of looking at it. And yeah, I guess I didn't put it in my notes here. Another way, Proudhund basically said that property is theft. And he likened, if you tell somebody slavery is murder, they immediately understand that and that means something to them. But if you say property is theft, they're a little bit confused. But the same sort of process goes on between the two, and it's probably similar to what Marx said, but in a different way. That basically somebody who doesn't contribute their labor ends up getting the profit or the value from the person who's done the work, and so that's in Proudhon's idea was theft. Okay, so before I start heading into all of the international legal stuff, one last perspective on property, but specifically land and territory, is some of the commonalities among the Austronesian cultural universe, which of course extends from Taiwan to Hawaii to Rapa Nui to New Zealand. And I quote this from, I think it's from, I didn't put the citation in here, but it's from Reuters. It's a little bit long, so sorry, I'll try to break somewhere in the middle. Reuters says, Austronesian-speaking people articulate their personal sense of belonging to particular places and lay claim to land and other territorial rights by invoking local histories of ancestral origin and migration. Origin histories are also inscribed on the physical landscape in the form of sacred sites and on the minds of local participants through their shared experience of ritual performance held at these sites. Together, these commemorative social practices generate a powerful sense of belonging and emplacement. People's rights to land and other localized resources and their social identity are thus inseparable, and both are defined by reference to time or precedent. Status and rights to land are indexed on their relative proximity to the sacred origin, place, or source, so that the ultimate ritual overlordship of a territory is often vested in the human representative of this source. And then he goes on to say, according to these models, people share a collective ritual responsibility towards the earth, which requires and promotes social cooperation. At the same time, they acknowledge that as individuals with a strategic interest in a political economy based on agriculture, people also have a concern for dividing and controlling land. Okay, so I just mentioned that because I mentioned a whole bunch of like European theorists, and I wanted to counterpoint that with basically this, what I would say to be not universal, but throughout the Austronesian island world is this basic sense, which I think in its highest form has evolved into Aloha Aina, but in a more abstract and general way is what Reuters has just described. Okay, so that's private property or isn't private property and how it relates to land in a way of thinking about it. So the next thing that I wanted to talk about was the idea of civil rights and cultural rights. And so I thought before we could get to cultural rights in the American legal context, it would be good to just briefly talk about the concept of minority communities and individual rights. And I'm not going to get into a discussion of the significance or what the ultimate meaning is that Hawaiians are a minority in their own homeland. But that is an issue, and it does tie into this in different ways, but I'm not skipping over it because it's not important. It's just that in order to get through all the other stuff, I can only talk about so much. So, okay. In the 17th century, the European powers had engaged in a whole bunch of wars and stuff, and it came to an end with something called the Treaty of Westphalia, and that was when the kings and princes of Europe agreed that they would basically stay out of each other's lands, and it also established before then a king or a prince, basically they supposedly had control over some extent of land, but the farther you got away from wherever their castle was, it wasn't really recognized. Like their authority sort of dissipated until they didn't have authority anymore. The Treaty of Westphalia changed that by creating like whole pieces of land that were part of a country, and that the sovereign exercised sovereignty over all of that land. So the Treaty of Westphalia was very important for modern nation states because it really created the concept of the ruler rules over a discrete territory of land, and that every piece of land is ruled over by somebody. Because before then, that's not how, no country exactly did it that way. I mean, even in China, that wasn't exactly how it worked. So what's important for our purposes today, though, it's a very interesting thing. And if you're interested in theories of sovereignty and stuff like that, feel free to research more in the Treaty of Westphalia. But one of the things that the treaty also did was that by carving up the land in this way, there were minority religious communities that all of these kings and princes decided needed to have protection. And so this is the first time in European law where basically a minority community based on religious affiliation is given protections. So that's an important moment in the idea of minority communities and individual rights, because it was a way that basically limited the sovereign's authority over people within their own territory. Okay. Then in the next century, there was a German philosopher named von Herder who created the concept of the Volk. And he, I think, is considered widely to be the father of what we understand as modern forms of nationalism. And that being that a folk are basically connected by common customs and language. And so if two people don't speak the same language, they're typically not part of the same folk or nation. And that had a whole bunch of consequences for the law later. But what was most important is at the end of the 19th century, there was a Congress of Vienna and then the Congress of Berlin. That Vienna, I think, that was to settle some disputes within the Habsburg Empire, and the Congress of Berlin, I think, carved up Africa. But long story short is these two congresses, what was important is that they expanded the protection of minority communities more than just religious minority communities into ethnic minority communities, or this concept of a nation or Volk needing to be protected. And of course, there was a whole bunch of wars between that and the end of World War I. And actually, I'll stop there for a moment because I did want to mention this, although I didn't write too much about it. So in the 19th century, as countries were, basically exploiting other lands, there were a whole bunch of treaties, particularly in Asia, but in other places, that were executed between European powers and like Japan, China, and so forth. And in all of these places, the treaties had what we now call extraterritorial rights, meaning that like if a British person commits a crime in China, that they will be tried by a court that applies British law with a British judge. And of course, today, I think most people just think that that's totally unfair. However, at the time that those were enacted, they actually were part of this concept that came from the Treaty of Westphalia and then the Congress of Vienna, that a ethnic minority should be entitled to the protections of their own government and should be tried by their own government. And so that occurred. Unfortunately, as the 19th century moved forward, it ended up just being another form of imperialism, where it was the white countries basically got to have their own law, but then everybody else was still subject to their law, or wasn't. It was just basically a way to hierarchicalize people into race-based things where basically the white people were on top. And so it should be noted that the first extraterritorial clause in any treaty in the world that was rescinded by a co-equal was when Queen Liliuokalani rescinded the provision of extraterritoriality with the treaty with Japan. And after that, the United Kingdom actually followed suit, and Japan, I think every country eventually gave up their claim of extraterritoriality, but it was actually Hawaii that started that in a global sense. And so I just want to mention that because I do think it's important that for folks to understand that the Queen and also King Kalakaua had this very progressive internationalist view of international relations and rights and that sort of thing. Okay, so World War I ends. League of Nations is created, and what was part of that system was granting minority communities some protection or rights. And so part of what the League of Nations did was it required that governments provide a share of public funds, maintain schools, religious social institutions, including court systems, for minorities within all of these countries that were basically created right after World War I. So unfortunately, it ended up being a horrible system. One, because in some ways, in some parts of the world, it was just basically reinforcing apartheid, and the non-white populations didn't get a fair share of anything. And then the other part of it too was like Germany started using this minority community system as a way to further German imperialism and Nazism that led up to World War II. And so I'm not going to rehash all of what happened in Europe, but just that the international legal community has this historical process. So because of that, after World War II, there was a huge turn away from communal rights and towards individual rights. And that was primarily from the experience of Hitler, but also a little bit of the experience of Japan as well, in a slightly different way. So, yeah, so after World War II, the world adopted a convention on the prevention and punishment of the crime of genocide. And the cultural genocide was not included in the final convention in 1948. And then in the 60s, there's the International Convention on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, the International Convention on the Elimination of All Forms of Racial Discrimination, and then, of course, the Declaration of the Rights of Indigenous People. So, and those have all primarily gone towards the individual right concept as opposed to communal rights, although the Declaration of Rights of Indigenous People does actually do both individual and communal rights. Okay, so that being said, that's basically there's two ways in the legal traditions, there's two ways of looking at rights. One is through this communal concept where it's a group that is conferred rights, and then the group through their own system figures out how they manage their people. And the other one is it's an individual right that an individual has against the government itself. Okay, well, the American system, the American legal tradition with cultural rights hasn't really fully figured out whether they're following the older minority community view or individual rights. Of course, when you go to court, you always have to raise things in terms of individual rights because that's how the American legal system works. But some of them rely on communal rights. So it's important to know that both of those things happen. So in 1889, I think this was in Michigan. I don't know. I don't have that citation. Indian marriage in this area, that the case was Kobogum versus Jackson Iron. The Michigan Supreme Court basically said that the Indians of this area allowed to have multiple spouses. And so any law in Michigan to the contrary would not be recognized as to these Indians because it was part of their custom and usage. That, of course, is contrary to a U.S. Supreme Court case that with the Mormons in Utah about having polygamous marriages. But in this case, and that was after that case, I think it was Reynolds versus the U.S. or something, that this case, Kobogum, was decided after that. And they basically said that Indians are allowed to continue to marry based on their custom. And then in 1964 in California, People versus Woody, the California Supreme Court recognized that state laws that prohibited the use of peyote do not apply to the Native American church because the Indians that are part of this church have a cultural practice that is recognized at law as being historic and continuous. And then in 1973, the U.S. Supreme Court ruled in Morton versus Munkari that because American Indians have a special political relationship to the U.S. government, that these sort of recognition of cultural rights is not a form of racial discrimination because the cultural rights that are recognized it's not based on the race of the person, it's based on them being part of a community that has a special political relationship to the United States. And so Morton versus Munkari is an important thing because without the U.S. Supreme Court recognizing that American Indians have cultural rights because they're part of a community that has a special political relationship to the U.S. government, then it would be then any kind of cultural rights based on someone's status as an American Indian would be treated as racial discrimination, which of course is generally prohibited under the 14th Amendment. So Morton versus Mankari is very important. And actually, I'm going to skip ahead because there was a case, Na Li'ielua versus Hawaii in 1990. And there was a challenge to the Hawaiian Homes Commission Act as being racially discriminatory, and the Hawaii District Court in 1990 ruled that they applied Mankari to Hawaiians and said that Hawaiians, as a nation of people, have a special relationship to the U.S. government that's akin to American Indians, and then they cited like 36 laws where the U.S. Congress has treated Native Hawaiians in the same way as American Indians. So that legal point is not fully decided. Yeah, is there a difference between lawful and legal? Well, legal, I think, is a more general, broad term than lawful, but I think the way that I've been using it, they're probably interchangeable. There might be a fine distinction under certain circumstances, but I think in the way that I've been using them, I'm using them interchangeably. Okay. Let's see, where was I? Oh, yes. So, yeah, so there were, in the American tradition of cultural rights for American Indians, in the 70s, there were a number of changes that occurred. The Indian Self-Determination Educational Assistance Act of 75 and the Indian Religious Freedom Act of 1978. The Alaska Supreme Court ruled in 1979 that Alaska natives who hunted moose out of season for cultural purposes were not subject to Alaska's criminal laws prohibiting moose hunting out of season. And then another important case, Santa Clara Pueblo versus Martinez, ruled that individual Indians were not entitled to sue in U.S. courts to challenge their disenrollment from their tribe. And so I mentioned this is very important because there's all of these rights that American Indians supposedly have in terms of their governance, but the U.S. government has decided that Indians can't go to federal court to protect those rights because they don't want to get involved in deciding who is the legitimate ruler of a tribe. The problem is that they actually do get involved in that because they basically give federal money to somebody who claims to be the ruler. So it's one of these things where the way the U.S. has done this is that it's actually allowed it basically has created, or not created, but it has supported in some instances tribal governments that do not have the support of their people, but their people have no way of remedying that because although the U.S. recognizes them for one purpose, they won't allow people to go to court. And so I've asked several times with some of the American Indian scholars who've come to Hawaii, so does that mean that like there could be an armed struggle and basically whoever the leader is would be removed from office because they're not allowing like the tribal members to go to court over this? And they always say, well, no, because if the Indians did that, then they would be prosecuted for federal crimes for so just to say that the U.S. government has not come up with a great way of dealing with tribal autonomy. And in some ways, they allow certain tribal governments to exist when they don't have the support culturally or popularly from their people, and they haven't figured that out. Okay, another important law that was passed was the Indian Child Welfare Act, and actually Hawaii courts are called to interpret this law routinely, and that is if a child is has a parent who is a member of a recognized tribe or the child themselves are enrolled in a tribe, that the tribal government actually has the final say over child custody matters. And so, yeah, so even if both of the parents live in Hawaii, the child was born in Hawaii, it doesn't matter. the tribal government basically gets the final say on where the child lives and who it lives with. So yeah, and actually I think there was a case, appellate case about 10 years ago where somebody adopted a child who is American Indian, and I think our courts set the adoption aside because nobody had consulted with, even though the parents agreed to waive their parental rights or terminate their parental rights, nobody had consulted the tribal government. And so the Intermediate Court of Appeals basically invalidated the adoption because of that. And it had been like 10 years. I think the child had been adopted. The child was already like 10 or something. It had already been long adopted, but there's no restriction on the Indian Child Welfare Act. So it is a very important law. Okay, I'm talking too much about that. So let's just briefly talk about cultural rights and sacred sites. So there's a case, Sequoia versus TVA, the Tennessee Valley Authority. And there was a Chota Cherokee that basically said, if you guys put a dam here and flood our the site, that it will deprive us of our ability to perform these very important sacred rituals. And they cited to a number of religious freedom cases that had occurred from the 1960s and early 70s. And they basically said that, that this site where they perform annual or more than annual rituals at was inseparable from their way of life, that it was the cornerstone of their religious observance, and that it played a central role in religious ceremonies and practices. But in that case, the court did not recognize it, and they made distinctions. And I don't know, it wasn't a great case, and the Supreme Court didn't decide to review it. So it is the law in the Sixth Circuit, but it wasn't a great case. The Navajo challenged the turning Rainbow Bridge into a national park where people could come in by boat and drink and do that kind of thing. That was also challenged. That was in the 10th Circuit, Baldoni versus Higginson. The Lakota and the Sisitsas, they challenged some activity at Bear Butte in the Black Hills, and that was, I think that was also rejected. Yeah. That, I think that was also rejected. The Navajo and Hopi tribe challenged the use of the San Francisco Mountains. I don't know if anybody's been to Flagstaff, but there's some mountains just to the north of Flagstaff that are considered very sacred. Some gods from the Hopi tribe travel between the Hopi mesas and these mountains, and some developer wanted to turn it into a ski resort, which it is a ski resort now, and so that one didn't win. And then this is, I think, probably the most important one, is Ling versus Northwest Indian Cemetery Protection Association. This was decided by the U.S. Supreme Court, and they ruled there. So what was happening is they were going to build a road through an American Indian burial grounds. And in that case, the Supreme Court said, quote, construction of the proposed road does not violate the First Amendment, that's the freedom of religion, free exercise provision, regardless of its effect on the religious practices of the respondents, because it compels no behavior contrary to their beliefs. So that was unfortunate. Shortly thereafter, Congress passed NAGPRA, which is the Native American Grave Protection and not restitution. Can't remember what R is. Act. And anyways, long story short is that any use of federal lands, federal money, there has to be this process for identifying the human remains and cultural objects of former and current Native Americans. It also creates a process for the return of unlawfully obtained prehistoric, historic, and former and current Native American homelands, human remains, and cultural objects. Okay, so that's the American system for cultural rights with respect to Indians, American Indians. Hawaiians in the context of American Indian law, of course, I mentioned briefly the Hawaiian Homes Commission Act of 1920, There's also, I'm sure everybody's familiar with the Admissions Act of 1959, imposes a number of duties on the state of Hawaii as a condition of admission into the United States as a state to do certain things for Native Hawaiians. There's been dozens of federal laws since the 1960s that treat Native Hawaiians as American Indians. And of course, I cited Nali'elua earlier as applying Mankari to the Hawaiian Homes Commission Act. Okay, Rice v. Cayetano, I'm sure if everybody remembers, that was Fred Rice, rancher, Big Island rancher, missionary descendant, challenged the Hawaiian-only voting in the Office of Hawaiian Affairs. Well, he actually did it about HSAC first, and then I don't remember what happened with that. And so then he challenged the voting in the Office of Hawaiian Affairs. And the Supreme Court in that case, 7-2, ruled that what the state of Hawaii was doing was a form of racial discrimination because, and the different justices had different reasons for doing this, but basically some said, under no circumstances can Hawaiians ever be treated like American Indians. And then others said, and this is what made it a majority, said that regardless of how Congress treats Hawaiians, the state of Hawaii can never engage in the state of Hawaii does not have a special political relationship to the Hawaiian people, that the only entity that can have that special relationship is the federal government. And so they struck it down. So that, of course, created a whole bunch of other lawsuits. That was under the 15th Amendment, which is the right to vote without respect to race. But Doe versus Kamehameha schools, which I'm sure everybody's familiar, there were actually a couple of them. And this is where there were non-Hawaiians that were trying to get into Kamehameha schools. This wasn't a challenge under the 15th Amendment. They have challenged Kamehameha schools' admissions policy under the 13th Amendment. I'm not sure if anybody off the top of their heads knows what the 13th Amendment. The 13th Amendment is the abolition of slavery in the United States. So just think for a moment that the folks who are challenging the admissions policy of Kamehameha schools are doing so under the abolition of slavery provision in the US Constitution. So, okay, I know that it totally sounds absurd, and it is, but let me just explain because it's not so far-fetched, but it is, I mean, it's still absurd. So in addition to slavery itself, one of the things that the 13th Amendment also allows Congress to do is to abolish the incidence of the badges of slavery. And so there's a Civil Rights Act, which was passed in the 19th century, that basically prohibited private forms of discrimination against Black Americans, because that was a way where basically slavery in certain ways in the South particularly was basically reestablished, even though people weren't slaves. Well, if you continue to treat people like slaves, even if they're not slaves, it still has an effect of keeping people in bondage. So that has a very specific historical purpose. And as you can see, it's been repurposed by people who are against Hawaiians to try to destroy things like Princess Pauahi's trust. There were a bunch of challenges also to a number of state programs, some of OHA's programs, under the 14th Amendment, which prohibits state actors from engaging in racial discrimination unless they have a compelling interest. All of those, the district court and the Ninth Circuit all ruled that the individuals who are challenging it did not have standing, and so those have never gone anywhere. But there is a concern about those who are within the American system are concerned that at some point someone is going to file a lawsuit that is going to destroy Princess Pauahi's trust and the other ali'i trusts, or under American law, or there's a concern that things like the Office of Hawaiian Affairs and all of the beneficiary programs are going to, and possibly some of the various laws that are used to remedy some of the things that the U.S. government and the state of Hawaii have done to the Hawaiian people, that those will be challenged and put to an end. And so without getting into any of the discussion, that is because of everything I've just described, that is the official basis for federal recognition. Whether or not that's a good idea, whether that can actually even be done, is totally beyond what I'm going to talk about today, because I'm just really more concerned about cultural rights. But I did civil rights as part of the thing, but I meant it in the context of cultural rights. So that's really what I'm going to be talking about. But just so that you understand, I'm trying to link everything to everything else so that you know where all of these things are placed. But it also does actually raise the question of like the American versus international, but it'll just go on forever. And I want to get through the last of this so we can start asking questions, because I think I'm talking longer than I was supposed to. So, okay. In state courts, there's a number of things similar to what I've described for American Indian law where Hawaiians' traditional and customary practices have been recognized. So first of all, in the state constitution since 1978, elevated what the law of Hawaii already recognized to a constitutional standing. Okay, so there were a couple of cases I'll just very quickly go through. Pele Defense Fund versus Ph.D. That had to do with the Waukele o Puna Forest Reserve. There was supposed to be a land transfer of Crown lands with Campbell Estate, and individuals associated with the Pele Defense Fund said that they basically had they had traditional and customary practices and on the Crown lands, and so that the state could not freely transfer them and extinguish their rights. The court agreed with them, but they said they need to have a trial because there wasn't enough evidence, because the court dismissed it without having a trial. So they said there needs to be a trial so that the Pele Defense Fund can prove what exactly it is that they are doing in the forest reserve. Pacific Access Shoreline Hawaii versus Hawaii County Planning Commission, PASH. That had to do with a hotel development in Kohanaiki in the Kona district of the Big Island. And there, the Planning Commission did not allow the families and the public access Shoreline Hawaii folks to intervene in the shoreline special management area permit process, basically saying they didn't have standing. And of course, the Supreme Court reversed and said, no, they do. And this is where the bundle of rights comes in, because what the Supreme Court said was that when Kauikeauli adopted a modified version of the American property rights system, not included in the bundle of rights was to absolutely exclude everybody from your property, especially if it was undeveloped. And so, yeah, I can't see what that says, but okay. So what that I remember when PASH came out, I was in high school, and it was like every private property legal expert was saying how communism basically had descended on Hawaii, and it was like a revolution against private property and all this kind of stuff. And of course, none of that was true, and none of it came true. But people, the private property folks, were very, very upset by PASH and continue to be. Okay, one more case of interest is the Kapa'akai o Ka'aina case. That another Big Island case. I think it was in Ka'u. The Land Use Commission. So the Constitution requires that every state and county agency, when they make decisions, that they consider traditional and customary practices of Native Hawaiians, and the Land Use Commission did not do that in this process of approving a change from the conservation to urban district for this proposed development in Ka'u. And so they sent it back to them, but they did provide standards. And so I have to say in my own practice that a lot of state and county agencies resist having to do a Kapa'akai analysis. And actually the most creative response that I've heard from a deputy attorney general is they say, that only applies to the Land Use Commission. Because that case was the Land Use Commission. And actually, I think possibly the AGs did that in our Public Utilities Commission case. Well, anyways, last year I represented Life of the Land and Hui Aloha Aino Kale Maile Ali'i in the Hawaii gas ratepayer case. And one of the things we argued was that they didn't do a Kapa'akai analysis, and that Kale Maile Ali'i had argued that, by allowing fracked gas and all of this fossil fuel stuff, that climate change will impact traditional and customary practices. It was actually, and they did it all without any attorneys. It was very sophisticated. And the Supreme Court agreed. So they sent it back to the